This is Barry Zalma on insurance. I am an attorney who has retired from the practice of law and now spend my time as an insurance claims consultant and expert witness, an author and producer of these videos. Today I'd like to talk about exclusions, because there is no insurance policy that insures against everything. In my experience, the shortest insurance policy I ever read said, quote, "We insure against all risks of physical loss except wear and tear," close quote. That was the entire policy, but it still had an exclusion. An exclusion is a provision of an insurance policy referring to hazards, perils, circumstances, or property not covered by the policy. Exclusions are usually contained in the coverage form or causes of loss form used to construct an insurance policy. One common exclusion to almost every insurance policy is a clause that prohibits coverage for an intentional loss. In some states, like California, a statute prohibits insurance of intentional acts. It is Insurance Code Section 533. It should be axiomatic that to pay for an intentional loss defeats the purpose of insurance, which is that insurance coverage is intended to indemnify for fortuitous events, not events which the insured anticipates and can avoid. To comply with statutes like the California statute, insurance policies contain specific exclusions to limit the coverages available to indemnity for fortuitous or accidental losses. However, not all apparently intentional acts are covered by the exclusion. Insurance policies contain specific insurance exclusions to limit the coverages available to indemnity for fortuitous losses, because there are some things insurance companies are just not willing to insure against. For example, the mysterious disappearance exclusion. The term mysterious disappearance first appeared in insurance policies in 1943. The term has been defined several ways, but all share the sense of an unexplained loss. It has been held that mysterious disappearance means a disappearance which is unexplainable, unaccountable, or which occurred in an unknown manner. In an action to recover damages for conversion in which the defendants, U.S. Art Co., Inc. and U.S. Art International Limited, commenced an action for judgment declaring that certain underwriters at Lloyd's had a duty to defend and indemnify them in the main action. The court refused the motion for summary judgment based on a mysterious disappearance exclusion. It also sought defense to the action by the owners of the art. The court found, quote, "Underwriters failed to establish as a matter of law that coverage should be barred based on the mysterious disappearance exclusion. The explanation for the loss proffered by U.S. Art employees, if believed by the trier of fact, could reasonably support an inference that the artwork was accidentally thrown away, which would take the loss out of the mysterious disappearance exclusion. In the event that it is determined that the mysterious disappearance exclusion does not apply, Underwriters will only have the duty to indemnify U.S. art for its losses. Pursuant to the language of the policy, underwriters had the option to defend, not the duty to defend, the main action. This is a case called Top Life versus U.S. Art, a New York appellate decision from 2007. Mysterious disappearance is loss under unknown, puzzling, or baffling circumstances which arouse wonder, curiosity, or speculation, or circumstances which are difficult to understand or explain. A mysterious disappearance is a disappearance under circumstances which excite and at the same time baffle wonder or curiosity. This is a 1946 case called Davis versus St. Paul Mercury, decided by the North Carolina Supreme Court. Now, sometimes people who suffer mysterious disappearance will claim that there was a theft. But theft is very different from mysterious disappearance, despite the fact that a loss of property results from both. Theft has generally been interpreted as any wrongful appropriation of another's property to the use of the taker. Courts are generally in accord in defining theft as including a taking by fraudulent conduct under circumstances which evidence an intent to steal. Evidence that establishes a mysterious disappearance is not sufficient for the insured to carry the burden of proving theft. Although one can infer theft from a mysterious disappearance, not all mysterious disappearances are a result of theft. At most, a mysterious disappearance is circumstantial evidence of theft. Insurance policies will therefore define terms like theft as the unlawful taking of property to the deprivation of the insured. Losses by mysterious disappearance can also be involved because policies that insure against the named peril of mysterious disappearance rather than exclude it exist in some inland marine policies and livestock policies who exclude loss by mysterious disappearance because livestock can just walk away. And if they do, there's no mystery to what had happened. For example, in a case that involved the disappearance of hogs, 2 of which returned, there was eyewitness testimony that some of the hogs had strayed. The court stated that conjecture, speculation, or choice of possibilities is not proof. It said there must be something more which would lead the reasoning mind to one conclusion rather than another. The court emphasized that the most plausible conclusion brings the loss of the hogs in the manner set forth by the evidence merely within exclusion of the policy. The claim for the loss was denied because the owner failed to produce evidence of theft. The hogs apparently just walked away. This was the Supreme Court of Nebraska in 1976 in a case called Gerhard Lovas versus St. Paul. Common, everyday meaning of the phrase mysterious disappearance should vary depending on whether the insurance policy in which it appears is a theft policy or an all-risk policy, or on whether the policy provides or excludes coverage for mysterious disappearance. Mysterious disappearance under the terms of a theft policy has been defined as disappearance under unknown, puzzling, and baffling circumstances. Livestock policies contain mysterious disappearance exclusions because, although livestock are often stolen, They have the ability to walk away from a farm without the need for the intervention of a thief. There is a provision in which mysterious disappearance creates a presumption of theft. By placing such a presumption in the policy, the insurer is creating a contractual rule of evidence. It is a rebuttable presumption. An insurer can prove no theft occurred. Such a provision does not insure for mysterious disappearance. A jury could conclude, on the evidence, that no theft occurred and refuse payment to the insured. Another exclusion, similar to the problems with mysterious disappearance, is the exclusion for loss or shortage disclosed on inventory. The mysterious disappearance exclusion is often paired with or followed by an exclusion for loss or shortage on taking an inventory because of the similarity of moral hazard raised by losses either unknown or not discovered until an inventory is taken. The inventory shortage exclusion is often misunderstood and more often misapplied. The exclusion in simple, clear, and unambiguous language states, quote, "This policy does not insure against loss or shortage disclosed upon taking inventory." Consider Betco Scaffolds versus Houston United Insurance Company, a 2000 decision of the Texas Court of Appeal, that stated its ruling was one of in first impression in Texas. Betco reported 2 thefts to the local police and to its insurer, far below the policy's $25,000 theft deductible. It was not until the annual physical inventory was performed that Betco claimed a loss of approximately $160,000. Although Betco attributed the physical inventory shortage to the 2 burglaries, Betco presented no evidence to support such an inference. The court, reviewing all of the facts in a way most favorable to the insured, found, quote, "Although Betco seeks to attribute the September shortage to the 2 burglaries, it presented no evidence to support any such inference. On the contrary, Betco's loss prevention manager admitted he did not have even the capability to determine whether any of the items discovered missing in the September inventory could have been taken in the burglaries. In theory, some or all of the September shortage could have instead resulted from a variety of other causes, including they could have occurred before or after the burglaries. It might or might not have involved an actual physical loss from an identifiable external cause, or it would be difficult or impossible to identify with reasonable certainty. As illustrated by the circumstances of this case, the court believed that the inventory exclusion provision reflects a recognition of the inherent uncertainty as to the causes of shortages which are only disclosed upon taking a periodic physical inventory. The court further believed that the inventory exclusion provision, like a proof of loss provision, reflects a recognition that an insurer should be afforded a fair opportunity to investigate the circumstances of a claim before circumstances change and memories fade, and where a theft is alleged, attempt recovery of the stolen items. The fact that an insurer can be held liable for failing to reasonably investigate a claim, as Betco alleged, further underscores the need to allow an insurer's investigation to be made while the greatest likelihood exists to collect meaningful information. the passage of time, and occurrence of intervening events can only operate to obscure relevant facts and defeat these objectives. Courts have concluded there is no merit in an insured's contention that the language such as shortage disclosed on taking inventory should be read as a limitation of the policy's exclusion scope. The use of the introductory phrase such as indicates unambiguously that the reference was intended as an example of a situation in which there is no physical evidence to show what happened to the property, not to limit the scope of the exclusion to shortages discovered during the taking of inventory. It would make no sense to exclude from coverage an unexplained loss discovered upon a formal taking of inventory, while allowing coverage for an unexplained loss discovered in the course of other activities. Now, insurance policies have dozens of exclusions, and we've only covered 2 in this video. But it should lead to further information for an insurance professional. This video was adapted from my book, Zelma on Insurance Claims, Part 102, Second Edition, which is available as both a Kindle book and a paperback from Amazon.com. If you wish to read about further exclusions, you need the book. If you found this video of interest to you, please refer it to your colleagues. It's free. And please subscribe to my YouTube channel or my Rumble channel or both, as well as my blog, so that you can be advised of future blog posts and future videos. Thank you for your attention.